No, three bills.
I believe three, Madam Chair.
Yes. Item number 13 will begin with SB 635.
Madam Chair and members of the committee, I'm pleased to bring this bill to you today. I would like to commence with amendments. First of all, if I would...
Is your mic on, Senator?
Testing, yes.
Okay.
A little bit of noise out here. To begin with, I'd like to offer some amendments. First would to be add Senator Leno, and Senator Leno, we talked about principal co-author, but would you consider joint author? Okay, we would like to add Senator Leno as a joint author. The second amendment, we would allow that, this is about those who are exonerated, and then compensation for their unlawful conviction or their unlawful incarceration. It's a liberty issue. And we are, this amendment would consider then counting as time that they served, the time that they served in jail prior to the conviction. So it extends that window. I consider that time that their liberty was denied while they're waiting, being sent to jail. And the other one would to take the word pecuniary from the code, and that would ensure a claimant who has suffered injury through erroneous conviction, losing their rights, but we're taking the word pecuniary out.
Yeah. Thank you.
So that said...
So you're taking
the word
striking
pecuniary
Thank you.
Okay?
Thank you very much.
This bill simply...
Senator, let me say there's no known opposition to the bill.
No.
So I think we can...
I'll just quickly summarize it. It allows then up to $140 a day to those who've been wrongfully convicted, exonerated. There are many examples and instances. Allow me just to tell you one story. This is an Oklahoma story, but the man's name is Greg Willoyd, and he was accused of killing his wife. He served a long time in death row in Oklahoma, was found to be wrongfully convicted of that crime. I later became a friend of his when he came out here to Sacramento and settled, and I conduct a seminar on the death penalty once a year. And I've had Greg Wilhoit come and testify many times of his experience on death row, and he was wrongfully convicted. Now, we're not talking really about the Greg Wilhoits of the world in the bill, but it is an example, an egregious example. So I present the bill. It is deserved for the liberty interest that they have had to sacrifice unjustly. Just start here with our witnesses. If you please go around the table.
Thank you.
Good morning, this esteemed committee. My name is Alex Simpson. I'm the Associate Director of the California Innocence Project, and I'm a sponsor of this bill and proud to sponsor it. I've seen firsthand the need for compensation and meaningful compensation for individuals who've been wrongfully convicted. This really just increases the cost of compensation commensurate with the rate of inflation. And if we acknowledge that we need compensation, and meaningful compensation for people who've been wrongfully convicted through no fault of their own, then this is a vote, an aye vote for this bill.
Thank you.
Yes, hello, Madam and Mayor, Senators. Hello, my name is Maurice Caldwell, and I am a 2011 exoneree. I spent 20 years, 6 months, and 9 days in prison for a murder I didn't commit. When I got out of prison, all I had was $57 from my prison account and the hand-me-down clothes the jail gave me to walk home in. I was fortunate that I had my sister, who had always believed in my innocence, to take me into her home. Without her, I would have had no place to go. I held 20 years worth of jobs in prison, such as janitorial, porter, librarian, but they never paid me for my work. Now I have degenerate disc disease, and I can no longer do manual labor. When an exoneree gets out of prison, they need help to get reestablished in this society. It's the state responsibility to help us because they were the ones who put us in there. We need places to live, clothing, therapy, a chance to go to school. to learn the skills we missed out on, and time to adjust to a world that's so different than the one we left behind. I'm finding my way, but I need help. Compensation will be a blessing when I get it. I thank Senator Nelson for recognizing that our lives are worth more than $36,000 a year. I lost my mother, my aunt, my grandmother, and my brother while I was in prison. I missed their funerals. I couldn't take care of my mother once she got sick. I missed out on 20 years of relationships, 20 years of family gatherings. Spent 20 Christmases in a prison cell surrounded by some of the most dangerous and heartless people in our society. No amount of money can make up for what I've been through, but meaningful compensation can truly help. I ask you to support this bill and support innocent people like me who will struggle for the rest of our lives to get over what happened to us. Thank you.
Thank you. Others?
Madam Chair, Nasir Hernandez on behalf of the California Attorneys for Criminal Justice, also in support and echo the eloquent words of the previous witness, and also thank the Senator. I'm glad to support one of his bills.
Fine.
Catherine Williams with the ACLU of California, also very proud to support this bill.
Paige Gainop from the Northern California Innocence Project, also proud to support this bill. Thank you.
Jim Lindberg on behalf of the Friends Committee on Legislation in California in support.
Thank you. Others?
Jesse Stout, LSPC, support.
Okay, others in support? Thank you.
Kim McGill from the Youth Justice Coalition, we're in strong support.
Thank you. Are there speakers in opposition to the bill? Seeing and hearing none, the bill has been moved?
Actually, I had a question. I'd be honored to be added as a co-author on the amendments you're taking today. It's an outstanding bill.
Please.
Yes. The bill has been moved. Senator Stone?
I'd be honored
Senator
to
Stone,
be
yes, of
co-author
course.
as well. Thank you very much for your bringing this forward, Senator Nielsen.
Right. And Senator Nielsen, I would like to be added as the co-author as well.
Very honored to have the committee
Madam Chair,
join us.
I think the
And Senator Money.
co-authoring by the entire committee
We could
says
be
it
a
all, but
committee.
Folks, I would tell you, this is a historic day.
No, it is. No, it isn't so historic. Come on, we've done this before.
if I could just say that I think it's important to recognize that it was Assemblyman Bowe who had originally authored the legislation that created the $100 compensation for wrongly convicted folks. I think it was around 2000.
Yeah.
And as demonstrated here again today, this is clearly a bipartisan issue. And I'm very pleased to join Senator Nielsen. I think it's our first Nielsen-Leno bill.
Yeah. Maybe, may it not be our last.
We're off to a good start, and I move the bill.
Please read the roll.
Hancock.
Aye.
Hancock, aye. Anderson. Aye. Anderson, aye. Leno. Aye. Leno, aye. Liu. McGuire. Monning. Aye. Monning, aye. Stone.
Aye.
Stone, aye.
That bill has enough votes to pass. We'll hold the roll open for the absent members. Thank you. Your next bill, Senator Nielsen, is SB 713.
Yeah. Okay, Madam Chair and members, this bill, the idea came to me is when I was chairman of the California Board of Prison Terms and saw the numbers of really dangerous individuals who did get formally deported, but who came right back and reoffended, many in very egregious ways. And our goal is to ensure that those who are really dangerous to the citizens of our state face some consequences. And if that consequence is deportation, again, so be it. But I realized that we needed to have an opportunity for them to face consequence, and that was beyond what the state could do. So I went to work with Congress in the 1996 immigration reform law to gain a provision in that law that stipulated if you are a formerly deported felon and illegally re-enter the United States, you were subject to federal prosecution and 10 or 20-year federal term as a consequence. Believing that if that was exercised that a few individuals might think a second time about coming illegally back into the United States. Sort of came home here last year when 2 deputy sheriffs in the area that I represent, or one of them didn't exactly live in the area I represent, but very close to it, was murdered by a fellow named Marcelo Marquez Bracamonte, who had been deported 4 times, illegally re-entered, came here, and one day murdered these 2 deputy sheriffs in a rampage of very historic and serious consequences. This is the kind of person that we're looking at. It's not to be a mass employed tool, but it does make sense that if you are formally deported and you legally come back into the country, then you're going to face a consequence. That is our goal. There's a high test, a high bar for such an individual. This isn't just a random pick of deporting people who are dangerous. You really have to pass the test here. You have to haven't been caught in the commission of a felony. You have to be unlawfully in the United States. You have to have been formally deported. You have to be caught committing an additional felony. We're dealing only with the repetitious and the escalating individual, those who are the most dangerous to society. I'll argue that this legislation keeps our people, the people we represent, safe and ensures justice.
Thank you. Are there individuals in support of the bill or speakers in support of the bill? Seeing and hearing none, are there speakers in opposition to the bill? Please come forward. You have 2 speakers, can have a minute each. After that, me too.
Jeanette Sanipatin, Legislative Staff Attorney on behalf of MALDEF, the Mexican American Legal Defense and Educational Fund. MALDEF was one of the original co-sponsors of AB4, the Trust Act. And regrettably, we are in opposition to the bill. We definitely believe that immigration holds are unconstitutional. So our concern is that we are, that since the Trust Act has been passed, a court has already found that immigration holds are unconstitutional. And that's because, we are not supposed to hold someone beyond the time for which they've already committed the crime. And so in order to hold individuals further for an immigration ICE hold, we definitely still continue to argue and believe that that is unconstitutional. Just 4 months after the Trust Act was passed in Miranda Olivares versus Clackamas County, the court held that ICE holds are unconstitutional, and that they violated the 4th Amendment's protection against unreasonable searches and seizures and ordered that damages be paid. Since then, many localities have also gone along and have passed ordinances to the same effect because of the unconstitutionality of these ICE holds. And for those reasons, we ask that you oppose.
Thank you. Others in opposition?
Good morning, Ronald Coleman here on behalf of the California Immigrant Policy Center, also one of the sponsors of AB4 Amiano, the Trust Act. Unfortunately, we must regretfully oppose as well. The tragic events of last year are extremely unfortunate, and the person responsible should be prosecuted to the fullest extent of the law. However, with all due respect, this isolated tragic event has nothing to do with immigration at all. In fact, the SAC-B did an editorial that denounced the issue of misguided attempts to turn this into an immigration issue and focused on the fact that this was an isolated crime spree that resulted in murder. The bill, SB 713, is a misguided attempt to gut civil rights provisions in existing law that this legislature put in place to ensure common sense protections for California's immigrants who had been subject to unjust detention and deportation. From the moment the governor signed the Trust Act, which created this minimum standard, there were a few rogue sheriffs who were waiting to exploit any situation to peel away at the Trust Act. Though immigration detainers have been found by courts to be unconstitutional, as we've heard from our colleague at MALDEP, this bill attempts to continue to legitimize that practice by removing these protections for individuals that have been previously deported for a felony. To the author, it doesn't matter that a person may have already served their time and it may now be a law-abiding, fully contributing member of society. It's just an opportunity to use an isolated, senseless tragedy committed by one individual to simply attack and scapegoat protections for immigrants. The framework of this policy is simply unworkable, as noted in the analysis. We aren't even sure how California would be able to determine how this policy would be implemented if it in fact became law, especially given the constantly shifting federal enforcement priorities and also the variety of reasons that a person may have been deported, regardless of whatever felony conviction may be on their record. With over 2 million immigrants already deported by the Obama administration, including 100,000 of those 2 million that live here in California, California should continue to be a leader as it relates to immigrant integration, and we should leave the scapegoating to Arizona and the conservative bastions within the South. This proposal goes in the wrong direction, and we should instead be fortifying our commitment to due process and equality under the law, which will help build trust between law enforcement and local communities. As we've heard from many law enforcement last year that testified, or in previous years that testified in support of the Trust Act. Let's maintain our values today and reject rolling back and gutting key civil rights protections for folks who keep our economy robust. For these reasons, we respectfully oppose and ask you to vote no on SB 713. Thank you.
Others in opposition?
Catherine Williams with the
If there
ACLU.
are others, please come up so we don't have to have a lot of walk time. Thank you.
Catherine Williams with the ACLU of California in opposition.
Khalif Osagai with the California Public Defenders Association in opposition.
Thank you.
Lima Murtaza on behalf of Asian Americans Advancing Justice, Sacramento, in opposition.
Kim McGill on behalf of the Youth Justice Coalition in opposition.
Maritza Gavis from the Youth Justice Coalition in opposition. My mother is an immigrant, and she would have qualified for this, so definitely in opposition.
Thank you. Thank you. Are there others in opposition? Seeing and hearing none, are there questions or comments from the committee, or is there a motion on the bill?
So moved.
Okay, the bill has been moved. Senator Nielsen, would you like to close?
If I may. Madam Chair, one of the witnesses here totally mischaracterized what we're talking about here. This is not about one individual. I mentioned Marcelo Marquez Bracamonte as an example of many. And I didn't pick him as an example of any ethnicity at all. I've had, in my years at the Board of Prison Terms, more problems with individuals from the European Covenant countries because I had responsibility to decide whether or not they could be released at their request to serve their time in their home country. So I've dealt with all of them. And one of them that comes to mind, and I'll use her name, Ana Kadisi.
I'm going to ask you if you would be not too long.
No, I
because we have
won't be.
6
I'm
bills to
just
hear
saying that
before noon.
the
Thank you.
testimony mischaracterized it. The bottom line is, as we've done things in criminal justice here the last few years, we're always talking about taking care of the really dangerous ones and protecting from the really dangerous one. This is the kind of person we're talking about, the really dangerous, not those who have illegally re-entered for other purposes, but those who are really dangerous and have been convicted repeatedly. I ask and I vote.
Okay, thank you very much. I'm not going to be able to support the bill today, Senator. I noticed that we have 37 cases in which law enforcement has a discretion for an immigration hold, or 37 various things, and I agree with the point in the analysis that how one would tell what the previous felony was and if that was the reason for deporting is difficult. But it's been moved And the motion is do pass. Please read the roll.
Hancock?
No.
Hancock, no. Anderson? Aye. Anderson, aye. Leno? No. Leno, no. Lou? Lou, no. McGuire? Monning? Monning, no. Stone? Stone, aye.
Okay, that, we'll hold the roll open for the absent members.
Yeah, that'd be fine.
Thank you. And then you have another bill?
Yes.
Number 19, SB 753.
753, I want to thank the chair for working with me on this very basic concept last year. It got hung up on the suspense calendar. We're coming back with higher hopes this year. It will significantly increase the amount of data that we have with post-realignment. It is absolutely essential that we know what's happening in our streets and in our communities post-109. There is no statewide data reporting system that allows us to track these individuals. It requires that it intends to achieve a grant process as well to provide the information counties would gather that decision makers, particularly the state legislature, could use. Furthermore, it addresses an issue that has long been neglected in criminal justice in California. Program after program that we've had in prison and in communities, we don't know whether they work or not. That's particularly been the case in prison. We need to have the data, and this is about the data. The bill passed unanimously from the committee last year. I assume there was some fiscal concern in the appropriation. I believe that we can overcome that. It's also supported by ongoing research by the Public Interest PPIC. They have collaborated with 9 counties now, trying to provide and gather some data to be helpful. It said, because 109, this is a quote from PPIC, because 109 establishes no incentive, resources, or standards for counties to measure outcomes, it will be difficult to assess that California's most significant justice reform in decades is working. It is whether or not. We need to take a look at whether or not realignment is working, but more importantly, the individual programs that are a part of realignment. And not, of the individual come out, we can track what success they had in custody based on what they did while they were in custody and then when they are in our communities. It's a very simple bill. I think post-109, a very necessary one.
Thank you. Speakers in support.
Madam Chair, members, Randy Perry with Aaron Reed and Associates on behalf of PORAC in support of the bill.
Thank you. Others in support? Are there, and while he's coming up, are there speakers in opposition to the bill? We didn't receive any opposition.
Khalif Assagai on behalf of the California Public Defenders Association in support.
Thank you. Are there questions or comments, or is there a motion on the bill? The bill has been moved. It was a good bill last year. I think it's a good bill this year. Would you like to close, Senator Nielsen?
I just submit that it really would be very helpful to us to know what works and what doesn't work. And that's good from those who have gotten on the wrong side of the law so that they don't do it again, and for all of us to be protected. I ask you and thank you for aye votes.
Thank you. Please read the roll.
Hancock?
Aye.
Hancock, aye. Anderson?
Aye.
Anderson, aye. Leno? Aye. Leno, aye. Lou? Lou, aye. McGuire? Monning? Aye. Monning, aye. Stone? Aye. Stone, aye.
Thank you.
Madam
We'll
Chair.
hold the roll
Thank you,
open,
members.
but that bill has enough votes to pass. I see Senator Pan is here. Item number 8, SB 453. Thank you. Senator Pan, welcome to the committee.
Thank you, Madam Chair and members. Pleased to present to you SB 453, and as I begin, I want to first of all thank the committee staff so much for working with my office and the committee and chair, and want to begin by accepting all of the suggested committee amendments that are proposed. SB 453 allows a treating physician working on a patient who has been declared incompetent to stand trial the ability to request another psychiatrist to place an involuntary medication order. The newly designated non-treating psychiatrist must be assigned by the Department of State Hospitals, or DSH's, state medical director, and must be briefed by the treating psychiatrist on the relevant facts of the case. The treating psychiatrist will remain the main and preferred psychiatrist, but can request another psychiatrist place the medication order if he or she feels endangered or if his or her relationship with that patient could be jeopardized. Current law already provides a detailed process that outlines involuntary medication orders. And after multiple failed attempts to have the patient voluntarily take the medication, a hearing must take place to determine if the involuntary medications are necessary. The Department of State Hospitals keeps internal data that has shown an increase in the number of injuries among treating psychiatrists from their patients after an involuntary medication hearing has taken place. This bill is intended to reduce that number of injuries in the workplace. SB 453 ensures worker safety while continuing to allow access to needed medications. We have worked closely with the opposition and the committee to create a stronger bill, and I respectfully ask for an aye vote. And I have witnesses in support from the sponsors, the Union of American Physicians and Dentists.
Thank you. No, 2 testifiers, no more than a minute, please.
Good morning, Madam Chair. Doug Chiappetta with the Union of American Physicians and Dentists with AFSCME. I will not be testifying, but merely delineating the support that we have for this bill. It's broad-based. It's stakeholders who've been involved in the State Safety Now Coalition, which is born out of stakeholders in the state hospital system about 5 years ago, initiated with the death of Donna Gross, who was a psych tech. Since then, there has been an uptick in the forensic population in state hospitals dramatically. This is an attempt to try and address violence within the state hospitals and to a greater therapeutic relationship with the patient and their staff. With me is Dr. Bussey. He's the president of the UAPD. Kobe Pizzati, he's with CAPT. Mark Victoria, he's with AFSCME 2620, and Randall Hager with the California Psychiatric Association on support. Thank you.
Thank you.
Good morning, Madam Chairman. There are thousands of ISTs incompetent to stand trial. 92% of the population of the prisons are forensic, unstable patients, and they reside in our state hospitals, and they represent both a real and a potential safety threat to those providers. It's time to shore up the rights of the state workers and our doctors. SB 453 does just that by allowing a discretionary substitute psychiatrist to make the decision to involuntarily medicate the patient. Currently situated RUAPD psychiatrists are in a very vulnerable position. Their position is as a treating physician, and they need to develop good trust and rapport with their patients. But if they act as decision makers for involuntary medicating the patient, they are not seen in that light by the patient. They're non-therapeutic and almost adversarial in the patient's eyes. The patient is not a healer, but becomes a judge. So this perception of the patient is not good for either the doctor or the patient in the long run. By allowing a therapeutically detached physician to play the bad guy in the treating physician will be both safer and effective for the patient.
Madam Chair, Kobe Pizzati with the California Association of Psychiatric Technicians. With, as Dr. Bussey said, over 90% of the patient population there on a forensic commitment. Nearly half of that population is... okay,
this was going to be...
We're in support.
Madam Chair, Randall Hager for the California Psychiatric Association. We urge your support. Thank you.
Thank you.
Madam Chair, Mark Victoria with AFSCME Local 2620, representing psychologists, social workers, and many others within the state hospitals in strong support.
Thank you. Oh, yeah.
Madam Chair, members, Khalid Pasagai with the California Public Defenders Association in support.
Okay, thank you. Let me just briefly describe the 3 amendments, and thank you for taking the amendments. Yes. Senator Pan, one is that we're going to specify the correct places in the section to which the bill applies, require the prescribing psychiatrist to examine the patient in person, and to strike the word the other from the reasons for appointing a non-treating psychiatrist. So, is there a motion on the bill?
Can I ask a question?
Yes.
Thank you, Madam Chair. Senator Penn, I support what you're trying to do here. I used to work at Rancho Los Amigos Hospital and dealing with severely psychotic, agitated patients, and certainly we want to minimize threats against prescribing psychiatrists. My only concern is for the agent psychiatrist that's writing the prescription, because he or she has not had any examination of the patient. Is there any way through this bill that we can indemnify that prescriber from any liability? Or is that what your amendment does?
That was one of the amendments,
Okay.
that the prescribing psychiatrist has to examine the patient in person.
So he does?
Yeah.
Right.
Was not in the bill.
Okay.
It's one of the agreed upon amendments.
But isn't that what's causing the agitation?
So the challenge is that you have a psychiatrist who's the primary psychiatrist for the patient. And what this bill allows them to do is to have another psychiatrist who's assigned by the medical director. So it's not just some random psychiatrist. Okay. And that psychiatrist also needs to examine the patient to ensure that they have to take full responsibility for the orders that they're doing, not just because, oh, well.
That was my concern. We had a physician that wasn't examining anybody, writing prescriptions, and I was worried about liability. I think it's been covered. Thank you.
Thank you.
I'll move the item.
Okay, the item has been moved as amended. And is there any opposition to the bill? Seeing and hearing none, the motion is do pass. I'm trying to see if it's fiscal. Do pass as amended to appropriations. Would you like to close, Dr.?
I respectfully ask for an aye vote. Thank you.
Thank you. Please read the roll.
Hancock?
Aye.
Hancock, aye. Anderson? Aye. Anderson, aye. Leno? Aye. Leno, aye. Lou? McGuire? Monning? Stone? Stone, aye.
That bill has enough votes to pass. We'll hold the roll open for the absent members.
Thank you so much.
Did I see Senator Leyva?